Good morning, everyone, and welcome back to our weekly webinar series. Over to Anil.
Thank you, Ankit. Welcome to 157th episode of AAA Weekly Webinar Series. Today, Ankit is not coming on the video because he is not well, but then he opted for participation into this episode as well. And he would be actively taking all the questions and he would be answering and would be providing his views. Not everything goes to Supreme Court. There are various procedural issues and there are various issues which are very, very important for the professionals and the stakeholders, which are decided by NCLT and the appellate authority, NCLAT. The practice can be improved and the decision making and the strategy part can be improved if we have the update on the latest views given by NCLT and NCLAT. Therefore, today's episode, 157th episode, is dedicated to various judgments given by appellate authority NCLAT. Because the NCLAT basically gives us most of the directions as regards insolvency professionals are concerned, for IRP, RP liquidators, and also for the resolution applicants, and also for the promoters and other stakeholders. The orders of NCLAT are very, and the first judgment that we are going to discuss is with the citation as IDBI Limited versus Z Entertainment Enterprises Limited. This judgment was given by the Chairman's Court, NCLAT, on 7th April 25. Now, the facts of the case, in fact, the IDBI Bank, on the request of City Network Limited, the borrower, sanctioned working capital facilities of about 25 crores, and then later it was enhanced to 150 crore. The 50 crore was fund-based and 110 crores were non-fund-based, secured by pari passu charge on the borrower's assets. Now, the City Network Limited is the borrower, and they had the pari passu charge on the borrower's assets. Loan agreement was entered in 2012 with the borrower, and the IDBI Z Entertainment Limited executed a corporate guarantee agreement in 2012 in favor of IDBI Bank to secure facilities granted to the borrower, and the borrower is City Networks Limited. Now, including the maintenance of debt service reserve account, borrower account became NPA in 2019, and in fact, you would recall that this particular judgment is a very, very great clarity on Section 10 capital A, which was introduced to circumvent the impact of COVID 2019. Because see, this particular section, in fact, kept out of the insolvency processes all the defaults which actually have triggered on or after 25th of March 2020 for a period of 6 months, or such further period not exceeding 1 year from such date as may be notified. So in fact, it was notified further. So it was 25th of March 2020 to 24th of March 2021 when this particular period, the period which was excluded from the insolvency processes under Section 10 capital A. So the first two judgments that we are going to discuss today, which is based on Section 10 capital A of the IBC. Now, when the facilities were recalled, it was February 21. February 21 is well within the recall period, well within the excluded period. Guarantee was invoked on 5th of March 21, and the Z Entertainment was called upon to pay 62 crores of rupees against that demand. Surface notice was given in July 21. and Section 7 application was filed in December 23, claiming 149 crores. Z Entertainment filed an application seeking rejection of the application, citing bar under Section 10A. NCLT found that the default date is 5th of March 2021, that is within the period provided in Section 10 capital A, hence barred initiation of IBC, hence Section 7 application was dismissed. Section 7 application of City Network was dismissed on an application filed by the grantor, which is Z Entertainment Limited, because this default date was 5th of March 21, which is well within 1 year period, which was exempted for the insolvency law, that is from 25th of March 2020 to 24th of March 2021. Now, the question of law, which actually were framed by the NCLAT, whether a petition under Section 7 of the Code is maintainable against a corporate grantor when the grantee is invoked during the period barred by Section 10A of the Code and no subsequent default outside the barred period is pleaded. Outside the barred period is pleaded. Now, in fact, let us try to understand that the Section 7 application was against the grantor. It was not against the borrower, because the borrower is City Network, whereas the Section 7 application was against the grantor. Now, the NCLT said that the corporate grantor's default was triggered on 5th of March 2021. And when we see Section 10A, which says suspension of initiation of corporate insolvency resolution process, it starts with non-obstante clause, notwithstanding anything contained in Section 7, 9, and 10, no application for initiation of CIRP of a corporate debtor shall be filed for any default arising on or after 25th of March 2020 for a period of 6 months or such period not exceeding 1 year from such date as may be notified in this behalf, provided that no application shall ever be filed for initiation of CIRP of a corporate debtor for the said default occurring during the said period. Said default occurring during the said period. Why I am focusing on during the said period? Because in the very next judgment, you would see what the NCLAT says, because in case this default continues, and then there is a possibility that the CIRP can be initiated and Section 10 capital A bar would be lifted. Now, in that explanation also for the removal of doubt, it is hereby clarified that the provisions of this section shall not apply to any default committed under the said sections before 25th March 2020. So there is only a bar in case the default triggers only between 25th of March 2020 to 24th of March 2021. That is what it is. It's Section 2010A says. Now let us understand what is this question of law and how the decision of the NCLT was. The decision of NCLT, in fact, the guarantee executed by the corporate debtor was a deemed demand guarantee, under which the grantor's obligation to maintain debt service account arose only upon a specific invocation by the lender. The clause 7, 9, and 11 of the guarantee deed made it clear that the guarantee could be invoked from time to time, and default would arise only when a demand is made. The lender was required to formally invoke the guarantee to trigger the grantor's liability. and no default could be claimed in the absence of such an invocation. That means there was a corporate guarantee. The default occurred in 2019, but there was no invocation of corporate guarantee. There was no notice to the corporate guarantor. There was no demand raised against the corporate guarantor. So that is where we are coming, because in case the demand is raised, in case the corporate guarantee is invoked during the barred period, then whether this insolvency can be started or not. Clause 25 of the general clauses, when the obligation of the guarantor of the general clauses of the corporate guarantee deed, guarantor are not conditional on the receipt of any prior notice by the guarantors of the borrowers. The demand notice by the lender to the borrower shall be sufficient notice to, on the demand of the guarantors. IDBI Bank categorically stated in its pleadings that the guarantee was invoked on 5th of March 21. The invocation occurred during Section 10A prohibited period, and that is what we finally NCLT said. Section 7 IBC application was founded solely on the 5th of March 21 invocation. No fresh default post 24th of March 2021 was pleaded or relied upon. Thus, Section 7 petition is barred under Section 10 capital A of the IBC. Further, NCLAT granted the liberty to file a fresh application or any default occurring after 24th of March 21. Now, this line is very important because the basic pleadings, the basic arguments, the basic prayers were basically focused on the date of default, which is 5th of March 2021. It was not having any kind of pleading. However, the NCLAT in fact granted liberty to IDBI to file a fresh application or any default for any default occurring after 24th of March 2021. So this last word that I'm saying, because this judgment is the latest judgment. And now we go to the another judgment which is slightly older than this judgment. Then we will understand why this liberty was granted. And now we come to this judgment. Now we come to this judgment, which is Vinod Kumar versus Omkara Asset Reconstruction Private Limited. This judgment is dated 4th of April 25. However, the judgment that we discussed before regarding the Z Entertainment Enterprises Limited, that is dated 7th of April, only 3 days after this judgment. So this judgment of 4th April 2025 is very important, coming from the same chairman's bench. Now, in this particular case, IndusInd Bank sanctioned a term loan facility of about 300 crore, where the corporate debtor was GP Realtors Private Limited. Repayment was structured as a bullet payment after 48 months with monthly interest obligation at 11% per annum. However, the default rate of interest was 18.75 per annum. Due to RBI's COVID-19 regulatory package, the repayment was deferred and the bullet payment was finally due on 11th of February 21, again within the debarred period, which fell within the Section 10A suspension period. And then due to COVID, the CD requested and was granted 3 months moratorium under the RBI regulatory guidelines. And that was also based on COVID-19. Now, what is happening? That this the payment was due in February 21. And then there was 3 months moratorium was also given. And then the original payment date of 11th of August 20 was extended first to November 2020 and then further to February 21. And the final due date for principal payment finally became 11th of February 21. The date 11th of February 21 fall within the suspended period under Section 10A of the IBC, which barred the insolvency filing for defaults during 25th of March 2020 to 24th of March 2021. CD failed to repay the loan. The demand notice was issued in June 21 after about 4 months for the principal amount of 272 crores and interest accrued. And interest accrued, I am repeating, and interest accrued of 15 crores. On the September 21 SARFAESI notice was also given, and then the IndusInd Bank assigned the debt to Omkara. NCLT Chandigarh admitted the application on 20th of November 24, holding the post 10A interest defaults exceeding rupees 1 crore threshold. Because see, in this particular application, there was a clear-cut understanding that in this particular default, 15.40 crore is the default of interest, and that interest default is in fact continuing beyond the period of 24th of March 2021. And therefore, this particular bench, Chandigarh bench, said that this particular So I see we were discussing the second application, second judgment of NCLAT on Section 10A, and it was like, as I said, the first judgment of NCLAT, where it was the liberty was given to the applicant bank that in case there is any other default which is continuing, the IDBI bank will have the liberty to file a fresh application. Now, in this case, the Chandigarh bench said that although the default triggered during the period, during the suspended period, however, there was a continued default of interest, and therefore the application was admitted only because the amount of interest post 24th of March 21 was more than 1 crore. So it was admitted. And now Section 7, the question of law before NCLAT was whether a Section 7 application under IBC can be admitted based on default of interest alone that occurred after the expiry of Section 10A period, even if the principal repayment default occurred during Section 10A period. And let us see what the NCLAT says. NCLAT upheld the admission of CIRP by NCLT. Observation of the court was like this. Now, the observations of the court, observations of NCLAT was: the financial creditor pleaded without prejudice that CD had defaulted in paying interest of 9.38 crore between 26th of March 21 to 31st of May 21, which is above rupees 1 crore threshold under Section 4 of the IBC. Though the principal default occurred on 11th of February 21, that is within Section 10A suspended period, the interest default occurred after 10A period and is thus actionable under Section 7. Then we are saying that the Section 10A only bars initiation of CIRP for defaults during its operations. It does not extinguish debt or preclude CIRP based on subsequent defaults, such as interest on continuing liability. The interest liability continues as per loan agreement, even if the principal fell due during Section 10A period. Now, NCLT correctly admitted Section 7 application barred on the post 10A interest default. So this is what is the judgment. And in case we analyze these two orders of NCLAT, in the first, where the pleadings and the prayers were not based on the continued default or any interest default, However, and therefore the order of NCLAT was that in case any default is continuing, IDBI Bank will have the liberty to file another application initiating the CIRP of that company. Now, in the second judgment that we have seen, which is slightly 3 days before, in this, it was allowed that the interest default was continuing. Therefore, the Chandigarh bench decision that it is correctly admitted CIRP is upheld. So therefore, the manipulation of the default date just to circumvent the CIRP and to bring it between the suspended period, that of course will now have limited impact, because most of the cases, the defaults are continuing, the defaults of interest are continuing. So therefore, this is a very, very important judgment. So Ankit, would you like to say anything on these two combination of judgments by NCLAT from the same bench, that is chairman's bench?
Yeah, I think they're like giving a lot of clarity with respect to the periodicity when the 10A will operate, and I think they are very spot on. Like anyone who would look at these sections closely and then understand how they should be interpreted would understand that this is very clear, good jurisprudence from NCLAT. If there are any other questions on these judgments, we can always ask participants to share their questions. So we don't.
Yes,
I don't have.
We will ask the participants to ask questions if they have. In the meantime, we move on to the third judgment of the day, which is Suresh Atlani versus Omkara Asset Reconstruction Company, again coming from the same chairman's bench, NCLAT, New Delhi. Now, in this particular case, it is a case of a colonizer. The GK Colonizer and Builder Limited, in fact, sanctioned a project loan of 94 crores. It was by Diwan Housing Finance Limited, of which 69 crore was disbursed. The appellant provided guarantee for the loan. Now, the company, the corporate debtor, declared NPA in 2016. Section 13(2) notice of SURFACI was also given, and there was one-time settlement proposal which was also approved, and partial amount was paid. Now, when this DHFL was taken over by Piramal Capital and Housing Finance Limited with effect from 30th of September 2021, a demand notice dated 13th of July 2022 under Rule 7 subsection 1 of CIRP regulations was issued for the defaulted amount. No payment has been made by the personal guarantor. Section 95 application was filed. DHFL assigned the debt to Omkara Assets. NCLT appointed RP under Section 95 of the petition. Personal guarantor filed objections before the adjudicating authority, stating that the RP's report was submitted beyond 10 days and hence cannot be accepted. So NCLT still admitted Section 95 application despite objections from the personal guarantor, saying that the RP's report was delayed, whereas Section 99 says that the report will be given by the RP within 10 days from his appointment. Now, the questions of law which was framed in this case, whether the 10 days period provided to the resolution professional for submitting a report under Section 99 of the IBC is mandatory or not, or it is a directory. Whether report which is submitted after a period of 10 days cannot be taken on record by the adjudicating authority or looked into for passing an order under Section 100 of the IBC, because the Section 10 report of the RP is placed on record for passing an order declaring insolvency of the personal guarantor under Section 100. So the basic question of law was whether that report which is filed in a delayed manner can be placed on record or it can be considered for passing an order under Section 100 or not. Now, the decision was that the appellant submitted, that the RP was obliged to submit a report within 10 days of his appointment. That is up to 26th of January 2024 in this case, whereas he filed the report only on 2nd of February, and thereafter he filed another report on supplementary report on 14th of February when he got some additional information from the financial creditor. 10 days period, it was held that 10 days period is directory, it is not mandatory. It is the word used, shall, in this context does not create a mandatory obligation when read with the overall scheme of section 99. And then the RP is empowered to seek additional information or explanation from the debtor, creditor, or any other person. Such persons are required to respond within 7 days. The amended report was placed on record via supplementary affidavit and was duly accepted by NCLT. Section 99 does not lay down any penalty or consequences for delayed submission, indicating legislative intent of directory nature. So now the Section 5 of the Limitation Act does not apply, as the 10 days period is not a limitation period. NCLT has the discretion to accept delayed reports if there is a proper explanation and no undue prejudice is caused. So most of the RP, they are in fact they normally encounter delays in this 10 days period, because even if they write to the applicant, even if they write to the financial creditor, the response is not coming within 7 days, or they are not getting the appropriate information. So therefore, in case there is a delay and if no prejudice is caused, then this word shall would be considered still as directory and not as mandatory, because the overall scheme of section 99, how the applications would be admitted and the insolvency resolution process is started, that process, the structure cannot be based on that if there is a delay of 1 or 2 or few days by the RP because he was not getting the information, so that advantage can go to the personal grantor. So that is what this judgment is. So Ankit, anything that you would like to add? It actually gives a little clarity to the RPs. Otherwise, the RP would be under stress, like in case there is a delay.
So I have seen within our office that we have, at all times tried to meet this deadline. And sometimes in the order to in the process of meeting this deadline, the report has no inputs from the creditors or the PG himself. So, because they seek more time, they are not able to give information within this timeline, and ultimately the report goes without their inputs. Even if they say that, okay, we need 2 more days of time to kind of give this input to you, the creditor says so, then also RPs, like in our office also, we have this practice that no, this timeline is very important, we should complete it. But I think, yes, that's what we feel so far. So I think in case you think that should change now based on this judgment, that yes, we should be a little RP should be a little flexible on this report and try to make a good or a comprehensive report rather than give it within this timeline.
No, my opinion is, Ankit, like in case the RP is not getting information from the various resources, including the applicant, creditors, or even the debtor, then he cannot be accused for the delay, and that benefit should not go to the personal grantor. That's what is very clear, that the benefit
So,
of this
so
delay should not go to the personal grantor.
So the benefit is not going to the person guarantor. That's very clear from this judgment that if there is a
Yes.
delay, then that delay is not something that the PG can take benefit of. But the question is that in case, let's say, a PG assignment comes in and I am supposed to prepare this report, and the creditor says, I can't give the information to you today, I can only give it by the 11th or the 12th day, and he sends an email to me. Should I then, like in normal circumstance, wait for that information and then prepare my report?
No, I think this particular judgment from NCLT and NCLAT is very clear that in case the report can be better, and it can be slightly delays. Not that the RP should keep waiting for months. The RP can certainly wait for a week or so, because in case the RP is expecting good information from other stakeholders, I think he can still wait for it, and he can provide comprehensive report as required from him. Okay, so should we move on to the next order?
Yes, yes.
So we move on to the fourth order of the day, which is RBL Bank Limited versus Sikal Logistics Limited. This judgment is from Chennai bench of NCLAT, and it is from Justice Sharad Kumar Sharma and the technical member Jitendranath Swain. And this judgment is in that manner. It is a judgment where the Cycle Logistics Limited, the resolution plan of this corporate debtor was approved by NCLT in December 2022, and the plan value was 425 crores. Now, the dissenting financial creditor RBL Bank was only paid 9.38 crore, being 9.88% of the amount available for distribution, which was 94.93 crore. Because he, out of the plan value of 425 crore, the only thing which was distributable was 94.93 crore, and the 9.38 crore was only given to dissenting financial creditor, which is RBL. However, the RBL filed an application before NCLT that the full payment of 42.09 crore as claimed that he is entitled to be paid on priority over the assenting financial creditor as per the plan and as per the presence of the court. Now, then the appellant filed an application seeking payment of the balance 32.71 crore and the enforcement of its entitlement as per the resolution plan under IBC. In the meantime, Sequel sought directions for release of title deeds of two properties required for asset sale as per the resolution plan. So NCLT held in this case that the dissenting creditor would be entitled to be paid with the amount that shall be paid to such dissenting creditors in accordance with Section 53, subsection 1, which has been provided in the plan in its clause number so and so of the resolution plan. The dissenting creditors will be paid in priority over the assenting lenders. So RBL Bank also challenged the release of the title deeds of the assets to Sikal Logistics Limited without its dues being fully paid. Basically, there were two issues. One, that after the resolution plan is approved, the resolution applicant wanted to sell two properties. He was trying to get the title deeds of two properties released, whereas the RBL Bank, in fact, tried to stop that. Also, RBL Bank contested that instead of an amount of about 9 crore, they are entitled to much more because of the resolution plan, because the resolution plan in this case was offering more amount than than the
Liquidation value.
liquidation value. So when we see the resolution plan, it was a resolution plan of 425 crores. Now we have to see what was the basis of arriving at the resolution plan value, which is 425 crore, whereas the distributable amount was only 94.93 crore. But finally, this is NCLT, the question of law which came before NCLAT, whether a dissenting financial creditor is entitled to receive payment based on its proportionate share of the resolution plan value and not merely the liquidation value, with priority over assenting financial creditors as per Section 32, subsection 2, clause B and subclause 2 of the IBC, and regulations 38, sub-regulation 1 and clause B of the CIRP regulations. And then when we see the decision of this court, one, the eligible amount payable to dissenting creditors when resolution plan value exceeds liquidation value. So in this particular case, the NCLT, in fact, NCLAT said that there was an error by NCLT in interpreting the section 30, subsection 2, and clause B and subclause 2 of the IBC by holding that the dissenting creditors are entitled only to the minimum amount equivalent to their share in the liquidation value. Section 30, the same section 30, subsection 2, along with explanation, mandates that the dissenting creditors must receive an amount not less than the liquidation value, and the distribution must be fair and equitable. That's what is mentioned there. And since now the NCLAT says, since the resolution plan value is 424 crore, which is higher than the liquidation value in this case was 352 crores, it is fair and equitable that the dissenting creditors to receive their pro rata share of the resolution value. Accordingly, 9.88% of RBL is entitled to 49.09 crore and not 34.78 as determined based on the liquidation value. All other dissenting financial creditors are also entitled to similar treatment. So now in when this interpretation was being seen, then it was also seen what is the clause 2 says. The clause 2 of section 30, subsection 2, clause B and subclause 2, it says the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of the priority in subsection 1 of the section 53. So that means that if the amount is more than the liquidation value, then the amount which is higher, that would be distributed to the dissenting financial creditors and not the liquidation value. So therefore, even regulation 38 1B of the CIRP regulation specifies that payment to dissenting financial creditor should be made in priority over those to the assenting creditors. So therefore, the clarification from this judicial the case is in case where the resolution plan offers a value which is higher than the liquidation value, the dissenting creditors are entitled to a pro rata share of the resolution value, not just the liquidation value. This approach ensures fairness and equity amongst creditors. The word priority, the court further says, which is again a kind of education to all of us. The court further says that the priority does not necessitate an upfront payment to the dissenting creditors. Instead, it implies that whenever payments are made, dissenting creditors should be paid before assenting ones. This holds true whether payments are made in full or in installments. So now what we are trying to say that in case a resolution plan is offering to the assenting financial creditors in a period of 1 year or maybe in 6 installments, then the priority means that whenever payment is being made to the financial creditors, first payment or first part of the payment, first check, first RTGS will be issued to the dissenting financial creditors, and then the assenting financial creditors will be paid, even if the payment is made in installments or in tranches. So this priority is applicable on all the installments and all the tranches. It is not possible that the assenting creditors are getting in 3 years and the dissenting creditors are getting in 3 months upfront. That is not what is the law. Law says that even if the repayment to the assenting financial creditors are made in 3 years, even the dissenting financial creditors will also get the payment in 3 years and not in upfront. That is a very, very important observations of the court, where the priority is also defined clearly. So therefore, NCLT upheld the interpretation emphasizing that the law requires payment in priority but does not mandate upfront payment. So the priority in payment in resolution plan means whenever any payment is released by SRA, the dissenting creditors will be paid pro rata. But in case where SRA pays amount at one go, then pay dissenting financial creditors first and then to other financial creditors. This is what is a very deep clarity that has been given by NCLAT, that the dissenting creditors will not have a right of upfront, whereas they have a right to get whatever amount is being offered in the resolution plan if it is higher than the liquidation value. Ankit, can we see the question, or
The
in case you have
so
anything
the
in mind?
so the difficulty here for RBL Bank, which I'm envisaging, is that RBL Bank will have to, let's say the plan says that this is how we will pay these amounts, and the plan talks about selling a property which is mortgaged with RBL. Now, if RBL and other bankers are getting payments in installments, future installments, and the plan provides for immediate release of the mortgage by RBL Bank, then RBL Bank will be at the mercy of the resolution applicant, that if he wants to sell that property and not pay or not complete the resolution plan later, then that person can do that. So this is the only difficulty here for financial creditors. So this kind of opens a backdoor that in case if there is a property which is mortgaged with a small voting share financial creditor, then the resolution plan can be structured in such a manner that the mortgage will be released sooner and the amounts will be paid after the mortgage is released.
Yes, this difficulty seems to definitely it can be this kind of difficulty is imminent. But Ankit, once a resolution plan is approved and it is binding on all, and if there is a default later, the RBL bank will come back to the original amount. But yes, of course, its property would be completely diluted. Its security interest would be completely deputed if after the sale of RBL assets, if the uh,
There's a default in the
if there
payment
is a
or
default and there are not much assets left thereafter. So
yeah.
that is where the difficulty lies, but that would be a very, very specific case
Yeah.
rather than generalized case. So I think we can move on to the next judgment, which is Sagar Stones Industries versus Sajan Kumar uh, uh, Dokania, again from the chairman's bench, Delhi NCLAT. This judgment was given on 28th of March 28. So this is a case of the CIRP of Jabalpur MSW Private Limited. The COC had considered 10 resolution plans. 10 resolution plans were considered by COC, including the ones submitted by the appellant. So the appellant in this case is again Sagar Stone Industries. Now the Sagar Stone Industries, in fact, the appellant filed two interlocutory applications seeking the rejection of the approved resolution plan uh, uh, and an inquiry against the RP, arguing that the process was not conducted fairly. Now, the first of all, the Sagar Stone Industries was one of the resolution applicant. The resolution plan of Sagar Stone Industries was not approved by committee of creditors. So therefore, Sagar Stone Industries filed two interlocutory applications, one seeking the rejection of the approved resolution plan and also inquiry against the RP, arguing that the process was not conducted. NCLT rejected the applications. Aggrieved by this Sagar Stone filed an appeal before NCLAT and contesting the approval of the successful resolution applicant's resolution plan and alleging procedural irregularities. Now, the question of law before Honorable NCLAT was whether the restriction imposed under regulation. Now, let us understand what was the basically procedural irregularities, which was in fact uh, alleged by the Sagar Stone. The first irregularity and the primary irregularity was under Regulation 39(1) capital A, sub-regulation 1 capital A, the resolution professional, which reads as the resolution professional may, if envisaged in the RFRP, allow modification of the resolution plans received under sub-regulation 1, but not more than once, or under a challenge mechanism to enable resolution applicants so to improve their plans. Now, in this particular case, the allegations against the RP was that the RP in fact went through many processes of negotiation, renegotiation, and the resolution plans were revised again and again. So that was the allegation against the RP. Now, in this case, the decision of NCLAT was that the NCLAT held that while Regulation 39, 1 capital A of the CIRP regulations limits the RP from allowing modification to a resolution plan more than once. So the RP cannot seek modification in the resolution plans more than once. No such restriction applies to the COC. No such restriction applies to the COC. So therefore, the NCLAT explicitly explained and stated that the Regulation 39, sub-regulation 1, capital A, prohibits the resolution professional from permitting more than one modifications of a resolution plan, but does not impose any such restriction on the committee of creditors. The committee of creditors is free to negotiate and seek multiple revisions to ensure value maximization. This is again a very, very important judgment. RP cannot invite for another modification, but the COC can actually interact with couple of resolution applicants. The COC can negotiate with them. COC can seek multiple revisions before the COC approves it. So this was the judgment, Ankit, because this also gives a lot of clarity. This also gives a lot of clarity for the procedures, for the actions of the RP, for the actions of the committee of creditors, because like in case such judgments are not coming, or in case such judgments are not read, then the RP and the stakeholders will be under confusion whether the RP has the power or the committee of creditors has the power. So it is very clearly the NCLAT has decided that the RP cannot invite for the further modification, but the COC can definitely have interaction with the resolution applicants and can seek multiple reasons in the resolution plan. So Ankit, I think there are some questions as of now, because I'll have two, three
Take up
more
the
minutes.
question. So see, I remember the time when this amendment came in, that the limitation that this can be revised only 2 times. At that point in time, the thought process was that this is being done to limit the timeline that gets involved in the negotiation process. So, in case the resolution applicant goes on and kind of thinks that, oh, I have to take care of 5 negotiation rounds with the COC, then he starts with a lower value and then he keeps increasing slowly. But in case he knows that this is my last plan and after that I cannot increase the value or I cannot revise my plan, then this will become the final value that he wants to commit. So
Yeah.
this was the thought process earlier, but I think this judgment is very clear that negotiation is permitted, and then thought process, I think now kind of gets diluted, which
Yeah.
was what was shared by IBBI in various forums when they came in with this change. Today also, when we see a lot of processes that we are taking care of, a lot of time is spent on negotiation with the resolution applicants, and then that makes the CRP period longer. That happens in many cases. We have a case from Kotak, from Mr. Vipul from Kotak. He says, in case of dissenting FC, if the resolution plan puts the plan which is approved, however, is less than the liquidation value, then how that situation will be dealt with for secured financial creditors who are dissenting? I think in that case, it's clear that the liquidation value will be the value based on which the dissenting creditor should get a value. But yes, we have many judgments which are contrary to the fact, and they say that whatever is the resolution plan value, even if it is less than the liquidation value, a share of that going to the dissenting financial creditor was also permitted by various courts.
But the law is very clear that the liquidation value, whatever is been assessed by the liquidators, that must go to the dissenting creditors, because see, the assenting creditors cannot accept a resolution plan which is less than a liquidation value, and while knowing fully that the dissenting creditors will have at least liquidation value to be paid. So they cannot do that. So therefore, the law is very clear. So in case there are judgments, those judgments are likely to be reconsidered by the senior courts.
Right. So that's about it. We can move to the next judgment.
See, moving on to the next judgment, which is Phoenix ARC Private Limited versus Kuldeep Verma, the liquidator. Again, this judgment is from the same chairman's court, Delhi NCLT. The liquidation process in this case, in fact, started. The KS Oils Limited, the liquidation, the order was passed on 21. The liquidation started in March 2021. Phoenix ARC, the appellant filed a claim of rupees 793 crores in Form B, and also in Form D expressly did not relinquish the security interest in Haldia unit, which was on 12.8487 acres plus some plant and machinery. So the Phoenix ARC did not relinquish that security interest in favor of the liquidation estate. The liquidator initially recognized non-relinquishment and handed over the physical or symbolic possession to Phoenix ARC. Now, after about 3 months, after 90 days, the liquidator invoked Regulation 21 capital A 3 of the liquidation process regulations, declared the Haldia unit part of the liquidation estate, citing Phoenix non-compliance with the Regulation 21 capital A sub-regulation 2, non-payment of dues under Section 53 within 90 days. Now, when we read Regulation 21 capital A and sub-regulation 3 or clause 3, it says where a secured creditor fails to comply with the sub-regulation 2, the asset which is subject to the security interest shall become part of the liquidation estate. So now let us understand what is the compliance required under sections 21A under regulation 21A sub-regulation 2. Now it says, this sub-regulation says that where a secured creditor proceeds to realize its security interest, it shall pay. Now it shall pay two things. One, as much towards the amount payable under clause A of subsection clause A of section 53, subsection 1. Now the clause A, let us say clause A, what it says. Now the clause A actually says that this amount which is payable as CIRP cost and liquidation cost, that will have to be paid assuming that the security interest was relinquished. And what else? Then it is also required to pay whatever amount is payable to workmen of the company as per section 53, subsection 1, and then the subclause 1 of clause B. So that actually says that the amount which is payable to workmen up to 24 months of the wages, the share of the creditor will have to be paid. So what is payable? One, any CIRP cost, even if it is pending or paid. Any liquidation cost, even if it is pending or paid. Total CIRP cost and liquidation cost, that will have to be shared amongst the creditors who would be getting an amount from the sale of assets. So that amount will have to be paid by the Phoenix ARC. Also, the amount which is payable to the workmen, the share of the Phoenix ARC will have to be paid. In case it is not paid by them within 90 days, then that security interest which was not released earlier in favor of liquidation estate will become part of the liquidation estate automatically. and then the liquidator will have right to sell those assets. So that is what is the important judgment today. In fact, the appellant filed an application before NCLT objecting to the inclusion of Haldia unit in the liquidation estate and opposing the auctions initiated by the liquidator. NCLT rejected the same. Thus, the appeal is filed. The appeal is filed by the Phoenix ARC, and the question of law is very important, and it says whether the liquidator was right in including the Haldia unit in the liquidation estate under Regulation 21 capital A sub-regulation 3 of the liquidation process regulations due to alleged non-compliance by Phoenix ARC appellant with Regulation 21 capital A sub-regulation 2, which says that the liquidation cost, CIRP cost, and the workman dues will have to be paid by the Phoenix ARC, by the financial creditor who is not relinquishing this security interest favor of the liquidation estate, proportionate to his share, proportionate to his shares. So the question of law was decided that Regulation 21 capital A sub-regulation 1, a secured creditor must communicate its intent within 30 days, failing which the secured creditor is presumed to be part of the liquidation estate. However, in this particular case, it was communicated to the liquidator that they are not relinquishing their security interest in favor of the liquidation estate. Regulation 2, in case it is not relinquished and the creditor proceeds to realize its own security interest, then there are two obligations on the part of the secured creditor. One, to pay the CIRP cost and the liquidation cost. Two, to also pay the share of the workman dues. That has to be paid. And in case there is any value realized which is more than their admitted claim, that has to come back to the liquidator within 180 days. Now, if the amount is uncertain, it may be as per the liquidator's estimate and later can be adjusted. So therefore, non-compliance of Regulation 21A sub-regulation 2 will make the asset as part of the liquidation estate. Now, when we see decision of the court says that the interpretation of Section 21A is as under. As per Regulation 37, the secured creditor must first intimate the liquidator of the price at which it proposes to realize the asset. Then, if a person is willing to buy the asset at a higher price, the liquidator must inform the secured creditor within 30 days. Then, the Regulation 21 capital A, inserted with effect from 25th of January 2019, and Regulation 21A sub-regulation 2 provides where a secured asset fails to realize, it shall pay. So it has to be paid within 90 days. And the decision of the court says the appellant, that is Phoenix ARC, have chosen not to relinquish its security interest in Haldia units. So therefore, it was required to comply with Regulation 37 and Regulation 21A. Then failure to comply with that will definitely say within 90 days, it will trigger the liability under Regulation 21A to A. The burden now shifts on the applicant to justify the delay or become liable for the corresponding amount as if it had relinquished the security interest. The decision says the secured creditor is required to comply with Regulation 21 capital A. The creditor cannot escape liability under Regulation 21 capital A sub-regulation 2 merely because the liquidator did not provide an estimate. Regulation 21A2 applies only where estimation is uncertain, not where no efforts was made. So therefore, the secured creditor neither intimated the liquidator of its intent to realize the asset nor sought an estimate of the payable amount in accordance with Regulation 37. The appellant was actively involved in SEC meeting, thus cannot claim ignorance or procedural lapses on the part of the liquidator. On the same lines, the appeal was dismissed. So, Ankit, although we have many other judgments, but I think the time is up and it is not possible for us to take up. However, we have decided that we would be giving two judgments of NCLAT every week under our earlier program, which was discontinued for some time, that is Voices from the Courtrooms. That will be restarted, and two judgments of any significant judgments may it be from Supreme Court, may it be from NCLAT, or may it be from NCLT. 2 judgments a week that we would be deliberating through a video which will be shared with our audience. Thank you very much. Ankit, would you like to say something?
No, I think these are very important judgments that we discussed, and I think yes, we are above time, so we should then close the session for today.
Thank
Thank
you
you,
very
everyone.
much. It is our way of learning. Thank you.
Thank you, everyone.